welcome back to Law and Crime Network, Law and Crime Report. I'm your host, Bob Bianchi. It's great to have you with us today. I hope you're having a great week. We got a lot on the plate today, from Kyle Rittenhouse to police cases to a cold case murder that's been solved to terror plots, all the way to our newest scenario with Scott Peterson. Amazing developments that are occurring with this case. You may recall, obviously, everybody knows the case, killing of his wife, Laci, of which he was convicted, and their unborn fetus. The death sentence was overturned by appeals courts in California, but now there's a new wrinkle. Let's listen to the defense attorneys as they talk about why the death sentence should be overturned, and then we'll get back to those new developments with you.
I have argued that, in fact, the guilt phase should also be reversed. Now, the state disagrees with me. I understand why. And let me state that there's been a lot of water under this bridge. I recognize that in many cases, this court has held that improper discharge of jurors under Witherspoon requires reversal only of the penalty phase. So it seems to me that the burden fairly falls upon me to persuade this court of 2 points. First, I need to persuade this court that this is an open question. It's not foreclosed by precedent. And second, it seems to me that the burden is fairly placed on me to show the court that in addition to not being foreclosed by precedent, that this argument is correct on the merits. Let me see if I can do those relatively quickly now. In terms of precedent, I don't think there's going to be any disagreement that Witherspoon doesn't resolve this under the Eighth Amendment. Witherspoon was a Sixth Amendment case. Indeed, it couldn't have been an Eighth Amendment case because it was decided in 1968, 4 years before the court began its march toward employing the Eighth Amendment in assessing capital jurisprudence processes in Furman. So Witherspoon isn't the Eighth Amendment barrier. The state, to its credit, recognizes that and says, well, this court has held that proper death qualification doesn't violate the Eighth Amendment. And the state is right. In cases from Hovey on down, and the U.S. Supreme Court has also reached this decision in Lockhart. But this is not proper death qualification, and that's important for 2 reasons. One, proper death qualification, and Hovey has an interesting opinion on this, and they use interesting language. Proper death qualification at least leaves the jury balanced. I think Hovey called it a neutral jury. Because after all, you may be taking off people that oppose the death penalty and won't consider death as an option. But you're also taking off the jury people who are in favor of the death penalty and won't consider life as an option. So the jury remains balanced. What happened here was a systematic exclusion of people who were opposed to the death penalty but would consider death as an option. Now, you weren't doing improper life qualifying under Morgan. The trial court didn't discharge people who were in favor of the death penalty but would consider life. That would at least leave a balanced jury of people who were indifferent, as I think the language, or neutral on the death penalty. So what we have here is something very different. We don't have a disqualification scheme that results in a balanced jury. We have a disqualification scheme that results in an imbalanced jury. So let me talk a little bit about why I believe that there's a need to reverse the guilt phase as well. And it's a relatively simple Eighth Amendment argument that depends on 2 principles. The first is that effective group deliberation is essential to reach a reliable guilt phase verdict. There's not much dispute about that. The second is that in a series of cases, the United States Supreme Court has made clear that the Eighth Amendment does not permit procedures which undercut reliability. Now, before I put these 2 together, I want to concede something. The defendant is not entitled to a jury of 12 people that are all skeptical about the death penalty and that may harbor a pro-defense bias and may harbor an anti-prosecution bias. But by the same token, neither is the prosecution entitled to a jury of 12 people that think the death penalty is swell and that harbor a pro-prosecution bias and an anti-defense bias. Reliability is best served when both groups are on the jury. Then there's the give and take that leads to a reliable verdict. And what happened here was the systematic exclusion of those jurors who were opposed to the death penalty but could consider death. And that removes a voice, a perspective from jury deliberations that I believe is essential to a reliable result. That's why I believe it's not foreclosed by precedent, and that's why I believe there is a Eighth Amendment violation as to the guilt phase.
Okay, I have with us 2 great guests, Professor Kirk Burkhalter, one of my faves. Thank you, Professor, for being here at New York Law, rather, as well as a 20-year veteran of the New York Police Department, a grade 1 detective. It's been a while, Kirk. How you doing?
I'm very good. How are you, Bob?
Doing well. And Dr. John Delatour, a psychologist in Arizona and Texas, a threat assessor, as well as psychological and consulting services. Welcome back to the show, Doctor.
Thanks, Bob.
Yeah. So, Kirk, I'm going to go with you first because there was a lot of heady stuff that was said there by the lawyer. I want you to tell us a little bit about what this Witherspoon issue is, but I want to give the audience some context here. The Supreme Court of California stated that, quote, juror number 7 committed prejudicial misconduct. That is what the trial court should determine, they're saying, by not disclosing her prior involvement with other legal proceedings, including but not limited to being a victim of a crime, and that she had answered 2 questions in the negative that turned out to be inaccurate at best, false perhaps as well, and that she was one of the 2 holdouts for a first-degree murder conviction with regard to the death of the fetus, so that she was somebody who was instrumental in seeking even more penalty against Scott Peterson. So the Supreme Court remanded it back to the trial court to make a decision as to whether or not this was prejudicial error. That's essentially what that lawyer was saying. Kirk, bring it home. What is he saying constitutionally is occurring here, and what do you think the likelihood of success is legally?
Well, I think that the defense attorney here made a rather eloquent and effective argument, to be quite honest. His argument is, and let's put it in plain English, is that the deck was stacked against his client, meaning the jury was stacked by this juror failing to disclose that she had been a crime victim and she feared for the life of her unborn fetus. That set forth a cascade of events. So first of all, since she didn't disclose that, neither side, neither the prosecution or the defense, had an opportunity to perhaps disqualify her as a juror or use one of their challenges to get her off the jury. And in effect, what they're arguing is, you heard the attorney talk about a balanced jury, not so much it should be in favor of my client or in favor of the other client. It should be a free shot, completely balanced. And this is critical because it's a death penalty case.
Professor, I was just about to ask you that. Tell us the difference between why it's critical because it's a death penalty case.
So the 8th Amendment prohibits cruel and unusual punishment. And broadly speaking, it's violative of the 8th Amendment if in a death penalty case, a defendant does not have a fair trial, meaning that you have an imbalance of jurors that are in favor more so of the death penalty and would not consider life in prison and so forth. So that's why this is so critical. I could see that certainly this going, being reexamined by the court, and because in our society, we just simply don't like to put people to death with all these lingering questions and sentence them to death or even life in prison. So it's a huge issue. And as I mentioned, I think the defense attorney made quite an eloquent argument here. He has a strong argument.
Nothing more heart-wrenching as a prosecutor when you're trying to do a hard job with a hard case. You get through it all. You're making sure you don't create any appellate error so that the case isn't reversed. And then a juror issue happens at the end of the case or here years later that threatens the conviction. I've been there. Unfortunately for me, it never got reversed, but it's just gut-wrenching. Doctor, let me ask you now, this case involves the death of Laci, his wife. He was supposedly having an extramarital affair. And the argument here is that juror number 7 was the victim of an ex-girlfriend of her boyfriend who was trying to attack her, and that she was actually worried herself for an unborn child, which is kind of directly related to the Peterson charges. What kind of psychological effect? The defense is arguing here that this juror had a predisposition because not only did she lie to the court, but it was something that was quite similar to the allegations made against Peterson. Obviously, hers didn't result in death. What are the psychological parameters, doctor?
Right. So a lot of people want to join the jury pool for any number of reasons. Some people, they want the law and order aspect of it. And some people are willing to do and say whatever they need to do and say in order to get into the jury pool. It's fascinating that there was someone with a similar background that chose to lie on a jury questionnaire. And so it sounds to me like perhaps there was something inside of her that was either triggered by what she had already seen, saw what case she could potentially be on, and felt compelled to be there and maybe not exact revenge for her crime, but perhaps maybe think about how she would want Laci Peterson to have justice.
Yeah, and I think that that's going to be something that's going to weigh heavily on the court. That the crime that she did not reveal was very similar in nature, and it only takes one juror to hang a jury. So that the defense has an argument here, and obviously the Supreme Court remanded it back for the trial court to make a decision as to whether or not this trial conviction should be reversed in its entirety. I want to go to a clip right now. At the time of the disappearance, of a personal phone call that was recorded. You may remember the paramour, if you will, or the person that he was having the affair with was an Amber Frey. Boy, these names are coming back from history for us. Let's take a listen to the clip.
You deserve so much better. There's no question you deserve so much better.
Yeah, and I deserve to understand an explanation of why you told me you'd lost your wife and this was the first holidays you'd spend without her. That was December 9th. You told me this, and now all of a sudden your wife's missing? Are you kidding me? Did you hear me?
I did. I don't know what to say.
Of course you couldn't tell me the story about your wife because it hadn't happened yet. And you were hoping to resolve in January that it'd be resolved and you'd have a story to tell me.
Do you think I had something to do with her disappearance? Ever you believe that?
Well, let's see. How can I believe that? How can I believe that? How could I believe anything for...
I am not evil like that.
I would hope not.
I am... Oh, my God.
You lied. Was Laci aware of the situation about me?
Yes.
She was?
Yeah.
Really? How'd she respond about it?
Fine.
Fine?
Yeah.
An 8-month woman fine? About another woman?
You don't know all the facts. Amber, you don't know all the facts.
Oh...
You know, Professor, damning conversations, but there are a number of people that believe that Scott Peterson is not guilty of the crime. There are times that the judges will look at cases like this and say that there was an overwhelming amount of evidence and that even if there was an error at the trial level, it's not enough to overcome based upon the amount of evidence in the case. But there are many who don't believe that he was guilty at all based on the evidence. Do you think that comes into play with the court's decision when they're now assessing whether this juror misconduct should result in a reversal?
Sure. It matters whether the error was prejudicial or not. So as you mentioned, there can be an error in the trial, one of many errors, but if it did not affect the outcome, if the defendant was not prejudiced because of it, there's a chance there may not be a reversal. So the evidence against Scott Peterson was quite damning. And even though the evidence was quite damning, like, as you mentioned, there are several folks that believe he didn't commit the crime. When you listen to the recording that you just played, the one thing that always bothered me as a investigator was when folks do not out and out deny the crime. So his response was, I'm not evil, I'm not that type of person, and so forth. The person who actually, well, more often than not, who did not commit the crime will come out with an overt denial. I did not kill my wife. Person that might tend to know more about the act will just talk about how I'm not the type of person, not evil, and so forth. So I think a court will look at all the evidence and determine whether, like I said, whether the error was prejudicial against him.
This would be a stunning development, folks, if this case gets reversed. And like I said, to no fault of either lawyer in the case. And this is why it is so important to make sure jurors are being truthful and accurate, but it's really hard to do that. And this could result in a reversal of the conviction in its entirety. We got a lot more on the plate here in the Law and Crime Report. Stay with us. We're going to take a quick break. We'll be right back. All right, like we said, in a stunning development, the Scott Peterson case, which had the death penalty conviction overturned earlier by courts, is now back at the trial court level because of a juror misconduct issue and asking the trial judge to make a determination of whether or not the prejudice created by that juror, who should not have probably been sat on that jury, should warrant a reversal of the entire conviction itself. And as we indicated before, with our awesome guests here, there are many people who do not believe that Scott Peterson is guilty of killing his wife, Laci, and their unborn child. One of those is Scott Peterson's former attorney. That's always an interesting insight. Let's take a listen.
Many of the jurors And everyone pretty much in the public was preconditioned to really convict him. I've always said it. Scott was convicted before he stepped foot in that courtroom for that trial. You know, anything is possible. We've seen many cases overturned, and it all depends on what the courts decide. But I'm keeping hopeful, and I'm staying hopeful that it does happen. Again, I strongly believe, just like many other on the defense team and his family, that Scott didn't do this, and he deserves another trial. Because we know that there was a burglary across the street on the day of her disappearance. And there was also some conversation between an inmate and his brother about accomplices involved in that burglary. And having said that, they saw Laci, and Laci basically tried to stop him. So there was talk, obviously on the defense side, that there's a great likelihood that they're the ones who kidnapped Laci because she caught him red-handed.
Doctor, I want to go to you on this one. It's always amazed me when lawyers are trying cases that how much they genuinely believe, the prosecutor believes their case and the defense really believes their case. And it kind of is like where you sit is where you stand kind of thing. And after each one is looking at the same evidence, what is this? Is this confirmation bias? Is this just wishful thinking? Why is it that the lawyers are so invested? Somebody's got to be wrong in that equation. Do you have any insights into that?
What I would say is that there's a difference between being on the side of the case and being on the side of the person. Being on the side of the person can be extremely problematic because some criminals are very skilled in manipulation and coercion techniques. And so if you're, as a lawyer, on the side of the person, you could easily fall prey to those kinds of manipulation and coercive techniques, charm and other things like that. If you're just on the side of your case and you believe in your case, well, I think that that's the kind of lawyer that I would want to have. But there needs to be an amount of skepticism. And so it's possible she is leaning in towards the person and perhaps falling victim to outside influences, his charm, his charisma, stuff like that. So perhaps some confirmation bias, yes.
Yeah, and I know you haven't done an examination, and it's not overall fair, but do you have any kind of assessment of Scott Peterson's personality in that regard?
Well, I mean, so for him in particular, he presents a very unique challenge because a lot of what he does could easily be considered transitory guilt kinds of behaviors where he only feels bad because he got caught. A lot of it could be reconstitution behaviors, which is he's going to do more pro-social behaviors to try to prove himself to be better than someone who would commit this kind of crime. These are things that we see in everyday people when they do something wrong. These are also things that we see with individuals who really have no regard for human life. Without having assessed him and really gotten an understanding for who he is as a person, he seems to be a very charming, very charismatic individual who can talk to people and feel comfortable around people, but seems kind of really to be in a sense narcissistic and in a sense having the spotlight kind of drawn towards him.
Very interesting assessment. I always love having you on because us lawyers are like amateur psychologists when we're trying to assess jurors and witnesses and defendants in a case. Let's take a little bit of a turn here in Idaho and another amazing case. Steven Pankey is arrested 36 years on a cold case for having killed a 12-year-old back in 1984. This was not solved by DNA. The body was found just in 2019, believe it or not. The determination was that it was a gunshot wound to the head, which was the cause of death. And the police officers essentially put this case together, indicating that they took a lot of the statements that the defendant was making, because he was constantly re-involving himself in the investigation, and that he actually gave details. One detail, very, very important, a rake that was used to cover snow tracks that only the person that was involved in the crime or being told by somebody that was involved in the crime would know, because it was never released to the media. So guys, what are your thoughts about the way this case was solved? The affidavit is basically saying that they just took a look at this case again. Professor, you were a detective, and they started putting all of these pieces together, including an amazing statement that he made, Professor, where he said that he could give them information if he was granted immunity, that he was looking for immunity. And they basically took that and a number of inconsistencies and some of the evidence that he was talking about that no one would know. This guy just had to keep talking to the police. And now he's facing murder charges. And to top it all off, this guy actually ran for governor of Idaho at one point. Professor, what are your thoughts?
This is a fascinating case, and not to make light of it. This is like an episode of the old show Columbo, where the defendant commits the crime and actually does a fairly decent job of covering his tracks, but just can't stay away from the investigation, probably thinks that he's brighter than the authorities, and that's what led to his capture. So this injecting himself in the investigation and making these statements, that was his downfall. Had he not done these things, perhaps the police would not have caught up with him. Who knows? Maybe there would have been some DNA evidence that led to him, but he just couldn't keep his mouth shut. And we see this over and over again. Folks like him, clearly has mental issues going on, but he's not a career criminal. That being said, there is information that apparently he was in some manner stalking children. So it's just an amazing case. He himself led to his capture. Not to say that this wasn't great police work.
I cannot wait to speak to the doctor on the other end of the clip of the Greeley Police Department press conference about the arrest. Let's take a listen.
It is with great honor today that we announce that the grand jury indicted an individual named Steven Pankey for the kidnapping and murder of Janelle Matthews. Specifically, the grand jury indictment charges one count of murder in the first degree after deliberation, one count of murder in the first degree felony murder, one count of second degree kidnapping, and two sentence enhancing crime of violence counts. Officers from the Meridian, Idaho Police Department, along with the Texas Cash Trail, arrested Mr. Pankey yesterday at his home in Meridian, Idaho. He's currently being held without bond in Ada County, Idaho jail, where he will await extradition back to the state of Colorado for state discharge.
Yeah, I should also point out that some of the evidence that they had was that he tried to create a fake alibi. And when the police went to speak to him after the body was recovered, he had deleted a number of searches that he was on his computer searching the girl's name and, all sorts of information, which obviously shows what the prosecutors will call consciousness of guilt. Doctor, what is it about guys like this? It reminds me of Robert Durst, who just can't stop speaking to the police. It's kind of like a moth to a flame. We just got done in our law firm putting out a book called an ebook called Silence is Golden. And everybody knows that's the smart thing to do. Why do folks do stuff like this?
So it depends on the psychological makeup of the individual, but it could be that it's attention-seeking behavior, they want to be a part of it. It could be sort of envy that they're not law enforcement personnel, or it could be just that they want to prove that they are smarter than law enforcement. There's a lot that's going on in this case, and we're so still early on in terms of what we actually know about his behaviors and about what he did. It's a long way to go from stalking children to then murdering them. There's a lot of other behaviors that happen in between. So this is one of those times where I'm going to tell the lawyer, whatever you got to do to get a psychologist to interview your client, you absolutely need to do that. There might be some mitigation issues, right? You need to know what exactly it is that person was thinking, because it's a long way to go in understanding his behaviors.
Yeah. Now, doctor, you mentioned a couple of things there. One of them was that he was alleged to have been stalking middle school children going to and from school. He's alleged to have committed this heinous murder and shooting this 12-year-old. What are the odds that this is just a one-off? The guy just decided to go out and shoot and kill a 12-year-old and never did anything else in your mind, based on what you're seeing?
No, there's no way that this was just a one-off. What I would say is a person who goes from stalking, right, observing, voyeuring children and stuff like that, they have long been fantasizing about engaging in some kind of hands-on contact. And so the longer they go with fantasizing about engaging whatever that hands-on contact behavior is, the more that they need to actually do that. And sometimes, well, a person can just do the hands-on contact, but then, like we talked about with Scott Peterson, there's a sense of guilt having committed some kind of offense behavior, and they're just trying to get rid of all the evidence that they can. But again, there's a lot of things that happen in between voyeuring and peeping on and stalking on children to then committing this crime.
Wow,
There's a lot going on.
fascinating. Professor, put your old detective school hat on for a second and tell us, my spidey instinct is telling me there's more there. What will detectives be doing in order? Because back then they didn't have computers, they didn't have databases, cases were siloed. We just recently saw this with Joseph D'Angelo in the Golden State Killer case. Are they going to be going through records and other investigative leads to see if there's other victims?
Absolutely. I would have to agree with the doctor that there are certainly a high likelihood of more victims. Had he been apprehended very soon after this crime, I would say that perhaps this could have been the first time, he just didn't have the opportunity. But it's been 36 years since the crime, and there have to be other victims. So the detectives will comb through records, find out, try to trace steps, where he was, when he was there, and put that information together with who went missing at that time. So it's going to be very unfortunate, but I would not be surprised if we find out that he was involved in several other murders. I guarantee you that the detectives are going to be all over that particular aspect of this case.
Yeah, and I would suspect, Professor, and sometimes this is just an unfortunate reality of things, that if they don't come up with any leads, the suspicion that both of you have presented of other crimes is so strong. Do you believe prosecutors will eventually make an approach and say, listen, if there's other people out there and you want to cooperate so we can bring peace to those families and admit your responsibility to this particular case, we'll be willing to cut you a break? Do you envision that would happen if they don't come up with any stronger leads?
I could certainly see that as a possibility, but it depends on what the bargaining chip is. So, in other words, if he's looking at life in prison for this particular crime, what are you going to offer him? A reduced sentence? That certainly is not going to help the family of this victim that has been identified gain some form of closure. I certainly could see the prosecutors doing that, but it really depends on if they have a bargaining chip. You know, if he's definitely eligible or something in that respect. They certainly have a duty to the other victims that are missing to try to ascertain as much information as they can. And clearly, he likes to talk.
Yeah, I was going to say, we could talk about this case forever, because I bet you there's a psychological component the doctor's going to talk about, Professor, that there are people that just love that moth to the flame thing. There's notoriety, attention, even if it's bad attention, it's giving them some level of affirmation. So you may not be surprised if they come forward with additional things. We've seen that in the gavel to gavel coverage that we've covered here at the Law and Crime Network on many occasions. Guys, thank you so much for the awesome commentary. This is the Law and Crime Report. We're going to take a quick break. We got a couple of great stories on the other side. Stay with us. Well, we now know about the infamous case out of Kenosha, Wisconsin, involving Kyle Rittenhouse. And the headlines read that he will not face charges in Illinois for rifle possession. A lot of people kind of went apoplectic about that in social media when they read it, but let's just bring a little perspective and clarity into what's happening here. Illinois is one state. Kenosha, Wisconsin is in another state. The shooting occurred in Wisconsin. And the quote coming out from law enforcement authorities with regard to the not charging him in Illinois for weapons possession is that the weapon was bought, stored, and used in Wisconsin. There's no evidence the weapon was ever possessed in Illinois. Guys, let me start with you, Professor, real quick. We're going to get to this a little bit later about where people just are jumping to conclusions and they read something and they get agitated, but there are legal issues at play. And while we need criminal justice reform, we don't need to throw the baby out with the bathwater, as they say. This is a no-brainer of a law enforcement decision. It doesn't mean he's going to get off in the murder in Wisconsin. It just simply means that weapons charges in Illinois are not going to be brought. He's still going to face the music in Wisconsin. What are your thoughts?
Absolutely. You know, we have a system of our criminal justice system dictates that all defendants are innocent until proven guilty. You have to have probable cause in order to charge a defendant. And certainly what we've seen all over the summer is we want that criminal justice system administered fairly. And here, if there is no evidence, everyone wants the book thrown at this kid, and perhaps rightly so. But if there's no evidence, there's no evidence. He will stand before and stand and face his accusers for the crime that he committed in Wisconsin. But if there's no evidence that he committed a crime in Illinois, we can't just lie and make up charges or just try to bring charges where they don't exist. That's not criminal justice reform. That's anarchy.
Yeah. Doctor, to that point about anarchy, I talked to us a little about the psychological groupthink that is happening right now, where we have sides pitted against one another. And it's kind of interesting to me to listen to those who advocate for civil rights and criminal justice reform, all of which I completely agree with and did when I was prosecutor. Those are worthy and laudable goals, but they're willing to throw out those due process protections, those very same things that they're arguing for their constituents and people that support them when it comes down to these kinds of cases. What is happening out there in your mind with regard to this? And can we ever come to agreement, do you think, or how do we get to agreement from a psychological point of view where we can actually stop screaming and yelling at each other, but make effective reform?
Just in general, what I would say is that the population has become extremely polarized. Name any topic that you want to name, and there's always going to be polarization. And I think one of the bigger aspects is where you get information from polarizes you to either one side or the other based on whatever that issue is. In order for us to start coming together and in order to start making true change, one group has to be willing to acknowledge that the other group's thoughts are appropriate and thoughtful. If you come at it already from an aggressive stance and saying that the other group is obviously wrong, then the other group has no choice but to stand their ground. So it's going to be important that one group take the opportunity to say, let me listen to what you have to say. And hopefully the other group does the same and say, let me listen to what you have to say. And slowly, unfortunately, slowly, inch by inch by inch, progress can be made.
Okay, well, let's dovetail this into Lancaster, PA. As you know, Mr. Richard Munoz was shot by police officers. They were called on a 911 call where it was indicating that he was had mental issues, and he was being aggressive towards his mother and attempting to break into their home. He came out, they say, wielding a knife. The officer shot and killed him. It led to demonstrations. Well, the district attorney, Heather Adams, has said that he is not going to be charged, that the victim in this case, who had mental disturbances, was 4 to 7 feet as they were approaching the officers, they determined, when he was shot. So let's throw to a clip of what the DA found was a justified use of force in this case, which I'm sure is going to cause the very kind of uproar between both sides that we were just talking about. Okay, events are unfolding quickly. Professor, as a police officer, former police officer, and now as a professor, I know during the break you have a lot of strong feelings about what we're seeing out there, and even some feelings towards what's happening with the police officers and the lack of training they have. Talk to me about that.
Absolutely. So this is it's a tragedy, and we've seen this movie before. We've seen emotionally disturbed persons confront police, and then there's no choice, right? It escalates, or it immediately escalates, and someone has to be the victim of deadly physical force through no fault of either side. And the focus is always on the incident, right? The seconds right there when those shots are fired. And I believe the focus should be on, one, the training and education of the police officers. And quite often, departments don't necessarily have the resources to train police officers to deal with this particular situation. However, there are other resources in jurisdictions. There are medical professionals. There are hostage negotiators within the police department. So when that call is made to the police department that, hey, there was someone in my home, they're acting aggressively, I fear for my life, they're dangerous, that goes beyond simply send the police. We're doing the police a disservice. We're doing society a disservice. That call means send the police, send a medical professional, and this may turn into a situation where this person will be barricaded and will have to negotiate. So I would encourage folks to think about what occurred prior to this incident, because this officer more than likely was justified. Officer was retreating, probably attempting not necessarily to use deadly physical force. But what happened? Could this have been avoided beforehand? That's my issue with how these situations tend to unfold. And they'll keep unfolding this way until there is reform on how these calls are handled.
Yeah, I mean, a worthy discussion, but Doctor, as the professor has indicated, from a legal perspective and a legal point of view, the officers don't have that kind of support. I don't know whether or not that could ever be accomplished, and that may actually put medical professionals in some level of harm. I agree we should try to move towards that end, but these situations with people that are mentally unstable are unfolding quickly. The police are being called by family members, which, the family doesn't want to call on other family members, that he's acting aggressive. They've got to respond there as quickly as possible. I don't know if you've ever had an opportunity to take a course in shooting or certification in shooting. They train for scenarios like this, but when you're being charged at with a knife and you're within 4 to 7 feet, even though you're mentally ill, what recourse in this particular case do you see for the officer, if any, and do you agree with the district attorney's conclusion that this was a justifiable use of force?
Yes, I agree with the use of force, and I agree with that it was justifiable. There are two things that I believe stand out to me and that need to be addressed. The first one is the quote from the DA that there was no time or opportunity for de-escalation. I train other professionals, lawyers, medical professionals, other psychologists in de-escalation techniques. There's always time for de-escalation techniques. And then the 911 caller had mentioned that the person had mental health problems. So that immediately should have triggered a crisis psychological response. And to the professor's point about what was happening before, I think this goes more towards how much funding are we given towards social support aspects. Was this person actually in treatment somewhere? Was he at an outpatient clinic somewhere receiving the mental health that he needed? Was he falling through the cracks? There's things that this didn't need to happen. The fact that it did happen, I think, the evidence shows that it was probably justified, but it didn't need to happen the way that it did.
Doctor, I completely agree. And I can tell you, when I was prosecutor, we got to a point where we started saying that the jail wasn't a place that we were putting prisoners. It's where we were putting people that were mentally ill because there was no place else for them to go. And the sad reality was they got better treatment in a jail from any kind of outpatient facility they could get. And so getting to it ahead of time, to me, is a huge issue. And unfortunately, we've defunded that in so many ways. And those poor people are left without their proper meds and proper treatment. And this is what you get. Guys, thanks for the great commentary. On the other end of the break, we are going to be talking about terror plots to take out governors because of their political positions on the coronavirus. We'll be right back.
We've been dealing with threats way back since January. They've been multiple. We obviously work very closely with our security detail. They work with local officials, the FBI. And this was just yet another threat to us. But, I think the message, John, is that certainly I don't govern under a cloud of intimidation. That's not who I am. And this is not about me. It's not about the governor of Michigan. This is about this country.
Virginia Governor Northam there. So let's break this down. How do we know some more information in this case? Well, an FBI agent testified at a preliminary hearing against the 6 men in federal court, stated that the motive for how this all started was due to their contempt at the coronavirus lockdown restrictions of these governors. What happened was a confidential informant gave them information. This is a great way to work a case. They wound up putting somebody inside of that group to listen to what it was that they were plotting and doing and going through their social media accounts. And they found out that the confidential witness at that point in time indicated they were going to overthrow several state governments for what they believed to be violations of the U.S. Constitution. They actually started a media group, believe it or not, where the plot was listed, the tactical training was being done, and they were actually trying to make bombs. And as part of the plan, we're going to bomb and attack police officers and EMS people to create a distraction while they, quote unquote, overthrew the government. Like, you take the governor out and all of a sudden the government's just going to disappear. It's a crazy plan. So Doc, let me go to you first on this, because I found something that was interesting in some of the literature there. And again, it's not political, but it's something that's important to bring out. There are comments that the president had made about liberate Michigan, liberate Virginia, and some are suggesting that that is what started motivating or at least incentivizing these people to move in that direction. I don't know if that's a fair commentary to make or not, but I do say, and know from my experience as a prosecutor, is that we have a group of people just underneath society's radar, if you will, for a long time that are either anarchists or, racists and people that are looking to overthrow the government, survivalists, things of that nature. And I always used to say to my wife, they're just looking for something to activate them. You have no idea how dangerous this is. I've been saying this for over a decade. Thoughts?
Yes, no, I would agree that it could have been anything. It just so happened to be this idea of liberate Virginia or liberate Michigan. It just so happened to be that thing. Some of them are going to say COVID-19. Some of them are going to say because the election's going to be rigged. They're just looking for an excuse for them to continue to engage in the behavior that they want to engage in. The thing is that there is a sense within all of these individuals that they're trying to do the right thing. It goes against what society would say is the right thing, but they feel compelled that there is something that is wrong that they can fix so long as they're given some kind of go-ahead, if they have some kind of goal that they know that they can achieve. So, I mean, it would have been anything, but you're right. They just need one little push to get the ball rolling for them.
All right, guys, we got to move on to another, crazy story. You got to love the Law&Crime Network, and I want to thank our producer personally for allowing us to do this story, because I found it fascinating. 2 Maine police officers are alleged to have beat porcupines to death. I'm not even making that up. They're the 2 officers right there. They are now fired. They were charged with beating the porcupines with batons, upwards to 11 of them. And they're charged with the depraved indifference to the animal life or suffering intentionally, knowingly, or recklessly causing extreme physical pain to an animal, death, or torture. Professor, you were a cop for 20 years. I'm gonna bet you never had to handle a porcupine beating case.
Absolutely never. So you know what this case goes to, and obviously the defendants deserve their day in court. So we don't know that right now it's allegedly occurred, but it goes to how those in power treat those who are powerless. And that's what we've seen all throughout the summer. So an animal is powerless to a police officer that has a baton, right? If you would treat a porcupine this way, where does it end? And that's the problem here. What do you do with your power? It's depraved, right? You judge people how they treat animals and children.
Great point. Doctor, real quick, I got 2 questions for you. Why do people do this? And secondly, an observation I made when I used to have to do press conferences with animal cruelty, people get more agitated at animal abuse than they do when actual human beings and adults are murdered. I found that out the hard way on a couple of cases. So why is that sentiment with people that way? And why do people do such horribly cruel things like this?
People do horribly cruel things for any number of reasons. A lot of it has to do with their own feelings of power and control. They believe themselves above whatever living creature. And yeah, as humans, we know that we're on the top of the food chain. We would just ignore a porcupine. Why would anybody want to be cruel to it? So the fact that someone would be cruel to an animal, it flies in the face of how we view ourselves in terms of our station here on the planet. And to the professor's point, I'd go a step further and start saying, if this goes to how the powerful treat the powerless, then how are our pre-employment psychological screenings?
Absolutely agree. Guys, we're going to have to end it there. I'm sorry to cut you off. We're going to have to end it there. Thank you very much, guys. You were awesome guests. This is the Law&Crime Network. You know we're doing things gavel to gavel. It's great being with you. You can find me at rbianchiesq on Twitter and Instagram.